All right, our second case this morning is John Nehmatallah and others versus Wilmington Savings Fund Society. Counsel, whenever you're ready.
Good morning, Your Honors. May it please the Court, Amanda Lundergan on behalf of the appellants John Nehmatallah, Paola, Cardenas, and the John Nehmatallah Trust. I'd like to reserve 2 minutes for rebuttal.
Okay.
We have 3 issues on appeal before this Court, and the first issue in our brief I think is the easiest and the quickest to address, which is at trial it was brought to the Court's attention that the defendants did not file objections to plaintiff's witness and exhibit list. Instead of holding a Binger hearing and discussing the 4 factors of Binger, the Court simply summarily ruled that the defendants could not put on any objections at trial, and all objections would be waived as not disclosed.
Why was that a?
Go ahead.
I'm sorry. Why was that a summary ruling at trial? Wasn't that already ruled upon at the time the pretrial order was issued? You keep calling it a sanction in the brief, but I'm not sure I understand why that is a sanction. You can choose to follow the order or not follow the order. And if you don't follow the order, it's self-executing.
No, not necessarily, Your Honor, because if you look at the cases that Binger stems from, it's exactly that. A trial order that requires the disclosure of something, that something doesn't happen, and then the Court is required, according to the case law, to analyze the 4 factors of Binger. Is there any prejudice? Was it willful? Was there any surprise on behalf of the other party? Was there an ability to cure those defects? None of that had been discussed, and in fact, the defendant wasn't even aware that they hadn't filed their objections to plaintiff's witness exhibit list until the day of trial.
Didn't they argue the objections, though? Wasn't that still an issue? They were allowed to bring up the objection and argue it, correct?
Objections were made after that point, but with each objection, the Court said, I'm overruling that because it's waived, because you didn't file your objections to the witness and exhibit list. But the problem is that the 4 factors, even if the Court had done the analysis, and it's clear, and plaintiff concedes in their brief, there was no analysis done by the Court as to those 4 factors. Even if the Court had done the analysis of those 4 factors, it would not have been able to make the conclusion that the objections should have been stricken, thereby making it a one-sided case where plaintiff can just shuttle in whatever documents, exhibits, and testimony they want, left unchecked. You know, this Court has an overarching precedent to protect the due process and make sure cases are decided on the merits.
Did the defense file an exhibit list of its own?
There was an witness and exhibit list filed. There was a pretrial stipulation filed. There was a conferral that was done. And
did the plaintiff list any objections to the defendant's exhibit?
They did not, and they concede that they did not.
So then it was a two-way street. The defense could have put in exhibits without the plaintiff being able to raise any objections.
The defendants weren't putting on any exhibits, I believe. It was just testimony and then crossing the plaintiff's witness. So there weren't really any exhibits for the plaintiff to object to.
But they could have.
Could have. But what's curious is the pretrial stipulation that was prepared by plaintiff's counsel references if there were going to be objections filed, because that defense firm always did file objections, and it routinely did a generic objection to the plaintiff's exhibit list, but none was done. And so plaintiff was aware that there were no objections filed. What's also interesting about the pretrial stipulation and the way that the Court's trial order read was if you weren't objecting, you were supposed to get a stipulation as to the admissibility of those documents. There was none done. And so plaintiff can't say that they were surprised by the defendant's desire to launch objections when they were basic objections to evidentiary things like hearsay and foundation, when their own pretrial stipulation didn't stipulate to the admissibility of those documents, and when they admitted that it was a very experienced plaintiff's firm who would have put forth objections normally. They also had the ability to cure it because they saw the pretrial stipulation. They prepared the pretrial stipulation. They drafted a sentence saying the objections were to be attached and saw there were no objections. They also know that it wasn't bad faith or willful noncompliance. The defendant's firm later filed a motion for rehearing and tried to assert evidence in support of their administrative oversight. This is very analogous to the Cazell factors. A lot of the factors overlap between Cazell and Binger. whether it was willful, whether it was a history of the firm doing these types of things. And it all harkens back to you shouldn't punish the client for the law firm's administrative oversight. We had an affidavit in support of our motion for summary judgment that said the way that the trial order was written, the obligation to disclose the objections wasn't a concrete deadline. It was kind of mixed in with the conferral and everything else. And so in our internal system where we flag all of those deadlines, we never flagged that deadline. And so it never got caught and it never got filed. So it wasn't an intentional act on behalf of the defendants, and it wasn't an intentional act on behalf of the firm. It was simply an administrative oversight. Those are the exact types of things that Binger and Cazell say shouldn't be passed on to the defendant.
Cazell really dealt with sanctions for attorney misconduct, right?
It does, and I'm not saying...
These aren't really sanctions.
Yeah, I'm not saying this is a sanction. I'm saying because they overlap, the underlying basis of not transferring and misfeasance of the attorney onto the client is a similar type of theory that applies in the Binger factors. If it was an oversight by the law firm, then the defendant shouldn't be prejudiced by that. And it's a severe prejudice to have to go into trial with your hands tied behind your back and not be able to have your objections ruled on the merits. And that's what's really clear from the transcript, which Your Honor pointed out. Even though the defendant still tried to make objections, the court was very clear that they weren't going to reach the merits of those objections. They were going to keep
let me ask you this to
overruling
follow up on Judge Grosshand's question. The judge did allow you to make those objections on the record, right?
Did.
Even though she was going to overrule the objections based on the noncompliance. But wouldn't it have been preferable for you to get her to rule on what her ruling would have been on hearsay, on authentication, foundation, whatever the objection was, so we knew what the ruling would have been?
And the judge made it clear that she was only going to rule on the fact that they were waived. Every time an objection was launched, whether it was hearsay, lack of foundation, document not in evidence, the court kept saying it was overruled solely because it was late filed and therefore waived. The court refused to go beyond that.
Was the court asked to go beyond that and say, Judge, notwithstanding your ruling, how would you rule on this hearsay objection?
I think it was because the defendants launched those objections. If the defendants had just sat down after the court said, I'm overruling your objections, and the defendant made no further objections, then maybe. But because the defendant still sought to try to preserve the record and make those objections, I think it was incumbent upon the court to analyze those objections or go back and do a Binger analysis and make some conclusions as to prejudice, ability to cure, and all the other elements of the Binger factor. It wasn't appropriate to strike those objections and basically handicap the defendant's ability to defend this case. These are cases that are solely based on documents, these foreclosure cases. It's all document-based, and so the plaintiffs are well aware that these objections are coming. If you don't elicit the basic tenets of a business records exception, you're going to get an objection. If you don't lay the foundation, you're going to get an objection. There's no prejudice.
Does the pretrial order say to list the specific objections?
It does, and what's
And
really,
does it say that if you do not, the objections are waived?
we don't dispute that. We don't
Okay.
dispute that it required it. That is standard language in every trial order.
And you also don't dispute that the defendant didn't list the objections?
Don't dispute that at all, Your Honor. We don't
So-
dispute that it was required. We don't dispute that the language said if you don't do it, it could be stricken. And we don't dispute that we didn't do it. What we
So then what
dispute-
you are saying at bottom is the order says do X or Y will happen. You did not do X. And therefore, for the court to enforce its order by doing Y, by simply enforcing its order, that is an abuse of discretion. That's what you're saying.
Because
To tell you in advance, if you don't do this, here's the consequence. It's an abuse of discretion to impose the consequence when you don't do what you were required to do, and don't call the issue of clerical error, as you're characterizing it, to the court's attention during the trial.
Two things. First of all, the language in the trial order doesn't overcome Binger. The Binger trial order had a requirement that they disclose witnesses and exhibits prior or face them potentially being stricken. So if Your Honor is to find that...
Was there a
simply-
difference between facing them potentially being stricken? I mean, I don't think the order said that, but in this case, the order did say, if you don't, then this will happen. You were put on notice. Both sides were put on notice. You don't file your objections, they'll be stricken.
But putting someone on notice doesn't eviscerate Binger. The court still has to go through the analysis because administrative oversight happens. It happens, we're busy, things fall through the cracks, and that shouldn't prejudice the defendant's ability for the case to be determined on the merits.
When
So
was the
if-
judge given a chance to consider administrative oversight?
In the rehearing, Your Honor. It was preserved in the rehearing. Quite frankly, because this was surprised on the defendants at trial, they would have had to go back and talk to their administrative staff to figure out what happened anyways. So it was preserved in the rehearing. The court looked at the rehearing and denied it.
But
There was
then
an affidavit
a notice
attached.
of appeal was filed before the ruling on the rehearing, right?
But that doesn't waive the rehearing. The Florida Rules of Appellate Procedure were amended in 2015, where a notice of appeal being filed does not waive your rehearing. It's just held in abeyance pending the outcome of the rehearing. Rehearing was filed, notice of appeal was filed, rehearing was denied 1 day after the notice of appeal. It's not deemed abandoned under the amended rule from 2015. So,
Doesn't Binger also say that it pays respect or will defer, at least to a degree, to the local practices of circuit courts with their pretrial orders and giving the trial courts the authority to enforce their own trial orders?
it will, and the court could have weighed all of these different factors at the trial, but the fact of the matter is it simply didn't. It didn't weigh a single factor, didn't ask about a single factor, didn't make a ruling or a finding on a single factor. The entire analysis was there was a requirement, it wasn't done, the objections are hereby stricken and waived. Nothing happened, there was no analysis, and so quite simply on that, unless this court's going to overturn Binger, it has to reverse and remand for a hearing on those types of factors.
Do you have any cases in which Binger has been extended to exhibits?
No, there are none. Plaintiff has conceded that Binger is applicable to this case, but the heart of Binger really is the court's ability to enforce its own trial order. And since this is a requirement that is contained within the trial order, it is analogous to Binger when it comes to being exhibits, witnesses, objections. All of those factors would fall under Binger, even though there is no specific case. This is a unique form of a trial order found mostly in foreclosure cases where you have to list the exhibits. Most other types of area of law, whether it be personal injury or whatnot, you simply stipulate to what you're going to stipulate to. Everything else is deemed to be objected to, and you're going to be prepared to do that at trial. Foreclosure cases have kind of cultivated their own trial exhibit with this unique requirement to list your exhibits. Would argue that this requirement is really not beneficial because listing your exhibits in a vacuum without knowing what the witness is going to say, how the document's going to come in, what foundational testimony, it's really not that beneficial to the other side anyways. So there can't be any prejudice from not receiving these exhibits because exhibits listed in a vacuum is really not that helpful.
Well, there's prejudice to the process of conducting an orderly trial. If the court has told the parties, you must do this, list your objections or they're waived. I'm not going to consider objections not made. If you just ignore that requirement, then you are creating a situation where you are unnecessarily allowing objection after objection after objection to be made. The idea here is to streamline the trial without having the opposing counsel say, well, may I voir dire the witness every single time an exhibit is offered. It adds horrendous length to the trial.
And that goes to the fourth.
And that does upset the administration of the trial.
And that goes to the fourth tenet of Binger, which the court didn't weigh. The court didn't make any findings that there was any disruption to the court. And in fact, the plaintiff went ahead and tried to lay its foundation and go through all the hurdles as if the defendant was going to make the objections. So there wasn't really any disruption because plaintiff put on its case the way it was going to put on its case no matter what. And the court didn't make any findings that what the defendant was doing or not doing was going to cause any delay in the case. So without those findings, maybe if Your Honor had been the judge, that may have been the finding you had made as a factor for, but the judge didn't make any findings here, didn't analyze it, didn't give any opportunity to make those. So that's the first issue on appeal, is whether the court erred in not applying the Binger factors, not doing any analysis, and just summarily ruling that the objections were overruled. The other two issues, very quickly, because I know I only have a limited amount of time. Second issue is whether the court misapplied the evidence rule. This is also a very simple issue. The bank attempted to introduce two witnesses. Those witnesses were admittedly not records custodians. They were being proffered as an otherwise qualified witness. In order to admit them, they had to lay the foundation of the business records exception. There are 5 tenets of the business records exception. They failed to introduce any evidence as to whether or not the document was created in the regular course of the business practice. The transcript is completely silent as to that tenet. Maybe it was a mistake on behalf of plaintiff's counsel in the case, just like the defendants made an oversight. But the truth of the matter is there's no evidence whatsoever to support that tenet. It was raised in the brief, and nothing in plaintiff's answer brief points to anywhere in the transcript where the witness made that statement. On that basis alone, the documents should not have come into evidence. They don't lay the foundation for the business records exception. Those records shouldn't have come into evidence. But going beyond that, even if the witness had said all 5 prongs and said all the magic words, the witnesses weren't qualified as an otherwise qualified witness. And this is really where we ask this court to take a look at a bigger issue that's going on in foreclosure cases, which is this anomaly of banks training witnesses just for the sole purpose of coming in to testify. It used to be that an otherwise qualified witness was someone who had sufficient familiarity with the records. But the plaintiffs have warped that into something else. What you saw in the transcript from the witness that testified in this case was never worked in any of the departments, never created any of the documents, didn't do his own independent verification of any of the information. His job title was a trial witness. His job was to review the records and then travel and testify at trial. That smacks in the face of what an otherwise qualified witness is. An otherwise qualified witness may receive training for a job function, but training for the sole purpose of testifying before this court can't be inherently reliable because their motivation is totally different than someone who's trained to perform a job in that actual bank. So when you look at that, that person couldn't have been an otherwise qualified witness. They never had sufficient familiarity with the records. Then go on and say what they were trained to do and what videos they watched about the other departments that are in this bank and other departments that are in other banks. But that's just hearsay. Being told what other departments do, being trained what other departments do, that's not the same thing as actually getting hands-on experience or familiarity. Now, the bank wants to twist this and say that we're saying they have to bring a person from every single department to match up to every single record that they want to introduce. And that's not what we're saying. The courts have for decades given them an option under the Florida statute to bring a records custodian affidavit in lieu of a live person, but they chose not to do that. That would have been much easier than trying to train one person who's never worked in any of those departments to regurgitate all of the activities and records and nuances of every other department, including entities that they didn't work for. So they had an option to do that. They chose not to do that. And because they, 1, failed to include all of the business records exceptions elements, and 2, were not an otherwise qualified witness, the evidence should have never come in. I have 1 minute left, so I'll address the last argument, which is plaintiff never had any evidence of standing. In support of their position that they were the holder on the day the complaint was filed, they brought in a witness from a law firm that brought a screenshot and a bailee letter. The problem is that at best, even if those were admissible and you set aside all the objections that were made as to the foundation, it only gets them that the servicer was in possession of the note, not that the plaintiff was in possession of the note. The bank wants you to believe that there was some agency relationship. The problem is that the power of attorney that they attached said, our agency relationship is confined to these enumerated duties, which are in a separate agreement, which was never introduced at trial. So we have nothing connecting the two. Then we have assignments. Plaintiffs specifically pled in this case that they were the holder. The assignments are irrelevant. And lastly, we have the Ortiz presumption. The Ortiz presumption says that if the note attached to the complaint is identical to the note they go to introduce at trial, there is a presumption that they are in fact the holder. The problem here is that there were differences. The original note only had said loan number but didn't actually list a loan number, and the note that was ultimately moved into evidence had a loan number listed on it.
Did you see the redaction on the copy attached to the complaint in the top left corner?
There is no redaction.
You don't see a blacked out
There's not
line?
a black box. It's white. Every other redaction on that document contains exactly that, a black box redaction. But on the note that was attached to the complaint, it's white. There's nothing there. It's as if there's no loan number ever typed into that space. Plaintiff's counsel at trial wanted to argue to the court that that was a redaction, but no testimony was ever elicited from the bank's law firm representative or from the bank's representative that that was a redaction. And the court can't presume that an empty white space is a redaction when every other redaction on the page was done with a black box. And for that reason, the Ortiz presumption shouldn't apply. There was no evidence of standing, and it should be reversed.
morning. May it please the court, my name is Adam Diaz on behalf of the appellee, Wilmington Trust. The first argument made by counsel today was that the objections should not have been waived. Essentially, the argument is a trial order has specific requirements. We violate the trial order, no harm, no foul, because everyone should have known we were going to object. Essentially, the argument is, in my position, would create a chilling effect on the trial courts that they cannot enforce their own orders. I think the issue here and what the record supports is that this was not an administrative oversight as articulated in the briefs. The trial order was entered on August 2017. The trial took place on November 9th, 2017. Plaintiff filed their witness and exhibit list September 1st, 2017, well in advance. The parties filed a joint stipulation together. This was not a unilateral one just done by plaintiff's counsel at trial. The parties reviewed it, including defendant's counsel. There was a section in the joint pretrial stipulation to include any sort of objections, and counsel didn't do it. This is even more important in this case than a standard foreclosure case because of the parties that were actually defending this case. The appellant in this case is not a borrower. This was a little bit of a unique case that the borrower in this case actually testified in the support of the plaintiff's case. The evidence at trial was that the borrower fell behind in his payments, met the appellant. The appellant said, "I will take care of this if you let me move into this home." He moved into the home. Property goes to an HOA foreclosure sale because the appellant advised the borrower not to make any more payments, that he was going to take care of it, and then the appellant purchased the property at an HOA foreclosure sale. The borrower wasn't even aware that he was losing out on the property. He thought that this was being taken care of. So the individual who is actually defending this case has very limited defenses in a foreclosure. I think the case law is clear at this point, coming out of the third and the fourth and the second, that they're limited to essentially standing, and potentially they can dispute the amounts due and owing. The exhibits that were admitted into evidence were not unique. They're standard exhibits for a foreclosure trial. The original note was admitted, a certified copy of their certificate of title, documents from the law firm showing that they received the note without redactions, judgment figures, power of attorneys, payment histories, default demand letters, and the letter log. With the brief from appellant and what was argued today, there's been no argument that any of the documents were wrongfully admitted and that the objections should have been sustained. I think, Justice Grosshans, you made a good point that there was objections made on the record. They were argued. One of the reasons some of the objections were sustained was, yes, it was waived per the trial order, which I think the court was in its discretion to do. But the judge also did hear the objections and made rulings. For example, there was foundation testimony that wasn't laid, and documents did not get into evidence based on those objections, so they were sustained. So the judge did hear objections during the trial. There's the argument that the defendant walked in with their hands tied, I think is, when you read the transcript, incorrect. The defendant clearly defended every portion of this case up until the entry of judgment.
Counsel, can you address the contention that enforcing these orders strictly tends to have courts, making a ruling based on the order that got violated, their own order, versus the merits of the case?
Well, I think in this case, the merits of the case were still contested and they were still resolved. But to Judge Orshfinger's position earlier, the judge has the right to conduct the proceeding and essentially prepare itself for how long these cases are going to take, particularly in foreclosures. There's a lot of cases on a docket. I believe the judge has the right to give parties notice of what their expectations are, and if the expectations aren't met, they can strike any of the exhibits, any of the objections, because the trial order specifically required that. And in particular, with this trial order, the parties had to get together and discuss this. Pardon me. And that is where this is different than just a strict, you violated it, we're going to hold your hands to the fire. In this situation, the parties actually discussed the exhibits in that joint pretrial stipulation, and it was still not raised. So I think the parties had more protection than it was just, you violated the order, you're going to be essentially sanctioned that you can't raise any objections. because it required the parties to meet, required early disclosures, required the plaintiff provide all exhibits prior, and it's uncontested in the record that all exhibits were provided. So I think if the court reversed the judge's ruling, what essentially we're doing is raising a chilling effect on trial judges, that they have to now go and spend extra time during a trial proceeding to go through all the Binger factors. The court made reference if there was any other cases that resulted from Binger regarding exclusion of exhibits or something like that. There was a case of Mystery versus Joseph and Sons. It's 827 Southern 2nd 391, which was cited in the brief. And in that case, the court did go through extending the Binger to violation of a trial order and finding that failure to disclose exhibits pursuant to the trial order, the court had within his discretion or her discretion to strike those exhibits. I think the standard is when we look at what was unreasonable. Did the judge in this case do anything unreasonable? And I think the record, this was nearly a 4-hour foreclosure trial. I think the record established that the judge did not do anything unreasonable, gave the parties the ability to present their case, make their objections even though they were waived, and in many instances actually ruled on those objections. And I think
if the judge was doing the Binger analysis in this case, and one of the factors looked at is prejudice, is it prejudice to the bank if the owner is allowed to make the objections, or is it prejudice to the owner if they're not allowed to make the objections, or is it some combination? Whose prejudice do we look at?
So I think in this case, the prejudice is established, presumed on the part of the bank because of the violation of the court order. It would have been the homeowner's obligation to show a lack of prejudice in this case.
Because it's not that the bank didn't know they were going to object to these documents, right? They raised an affirmative defense challenging the authenticity of all the bank's documents, so the bank was on notice if they were going to challenge them.
Well, the bank's on notice in the affirmative defense is that there will be challenges, but now when we're preparing for trial and preparing our presentation to the court with specific orders, and I'll note, not every court in Florida has a specific trial order requiring the laying out of objections. This is specific to this court for this case. This is not a standard order across the state of Florida. So when we're preparing for trial and the presentation of our case, how long we're going to take, how many exhibits we're going to have to enter, and what our witnesses are going to have to testify to. And this goes to the judicial economy. I mean, the court has the ability to run its court the way it seems fit and in the most judicial economic way. By requiring the parties to get together beforehand, and I understand everyone's busy, and that is what the argument was made, that everyone was busy and therefore there was some administrative oversight. But what the court requires everyone to slow down for just a second, do that joint pre-trial stipulation so everyone knows what we're going into, including the judge. So the judge has the ability to know how quickly is this case going to be able to move. So I think the prejudice in this case is that the homeowner should have established a lack of prejudice on the bank versus the bank establishing prejudice. And again, this case is a little more nuanced than the other cases because we have that fact. This is not a borrower. So this is not an individual who signed the note. This is not an individual who's personally liable for anything. So regarding the striking of the objections, I think the transcript is clear. The judge still heard, and I don't think the briefs or anything established that any of the objections that were made or that would have been made, any of the exhibits should not have been admitted into evidence. The second argument made is that essentially there was a robo-witness at trial. 2 robo-witnesses at trial is what the argument was. So at trial, the plaintiff called 3 witnesses. One was there was a records custodian, the head of the records department for Cash Schuler, and that was the law firm that tried the case. That witness competently testified regarding the computer system of Cash Schuler, that the documents were made at and near the time of the event, met all of the business records exception, identified the individual that received the note and mortgage, introduced into evidence a copy of the Bailey letter with the note and mortgage that they received without any redactions to establish they did receive it with no redactions, and established that they possessed it. The record was clear that that was an individual with knowledge of the records of Cash Schuler, was competent. He was a manager of the records department of Cash Schuler, and was competent to testify that the documents that were admitted into evidence were the business records of the law firm of Cash Schuler to show that they possessed the note at the time of filing on behalf of the bank. The second witness that testified for the bank was Mr. Younger. Mr. Younger was the was the records custodian of Rushmore. He's also a trial witness, is one of his titles. He went through pages and pages and pages of testimony about his training at Rushmore, his ability to review the MSP system at Rushmore, his familiarity with this loan in particular, the documents he reviewed prior to coming to trial, his ability to access the records prior to coming to trial. He talked about how he's trained with each department at Rushmore. Just because he doesn't work in the department doesn't mean he's not a qualified witness. He had physical training, continuing training, which is in the record of each department for every document that was put into evidence. Secondly, the payment history of Bank of America that was put into evidence. Mr. Younger went, I believe it was about 2 pages in the record, about Rushmore's boarding process on what they do to review and validate that payment history before accepting it into the records. And as a second level of competency, Mr. Younger actually worked with Bank of America, had training at Bank of America with their payment history department, was aware how they were created, had, when he was at Bank of America, access to their records that they had, so they were able to review the documents. He was familiar with that. The testimony was clear, and it was thoroughly drafted in the brief that each individual had competent knowledge on their own internal systems, how their records are created, and were qualified witnesses to introduce the documents into evidence. The brief is silent on the appellant side on what was actually missing. There was a lot of complaining that it wasn't good enough, but there was no specific articulation on what was actually missing. Same thing with the objections. What was actually missing in the presentation of this trial that burdened this defendant, that would have changed the result of this case? And it wasn't. The last argument that was made today was regarding standing. A lot of focus in the brief was on the Ortiz presumption, but before we discuss the presumption, what was the actual evidence put into the record? The plaintiff filed this lawsuit. The original complaint did have a note attached with white redactions. I did not see any black redactions, but they were white redactions in this case. However, the endorsement was not redacted. The original note that was filed with the case had the same endorsement. The endorsements matched, the hole punch matched, the staple parts matched, and the judge goes through a long process during the trial to compare the two to see what looked the same in the complaint and what is different. And the judge found 2 things were redacted. The loan number from the original complaint was redacted, and there's a barcode that was in the complaint that was redacted. So that was the court's determination that they were the same, and that the endorsement at the time of filing matched the endorsement at trial. Additionally, the law firm that testified, which it's okay for the law firm to hold the note on behalf of the bank. That was found in U.S. Bank versus Angeloni. That was a 2016 case out of the 4th DCA that specifically said a law firm can hold, as a bailee, as an agent, the note on behalf of the plaintiff. The law firm testified and presented evidence that they received a note with no redactions. What was admitted into evidence was a copy of the note from the law firm without any redactions. So what the record establishes is that the law firm received the note from Rushmore, took the note, redacted it, filed the complaint. And the reason they redacted the loan number and the barcode is because they were required under the rules of judicial administration. So it wasn't unique that these were somehow altered documents. We're required by the rules to redact. But what's really important, besides the loan numbers, that the actual allonge was the same manner in which it was prior to filing and at the trial. The other argument is that the power of attorney did not give Rushmore the ability to testify or hold a note. That's patently false. The power of attorney in this case enumerates a number of items that the servicer can do, and specifically the first paragraph says the servicer can foreclose on behalf of the trust. That's enumerated exactly in the power of attorney. The fact that there's an additional servicing agreement that's a reference does not show that this document is an incomplete document. It's not. It is the document that gives the servicer the right to do what they have to do in court. Additionally, U.S. Bank versus Clark, this is another case out of the 4th DCA, specifically said you also have to take into account the testimony of the witness. In this case, the witness specifically said that, yes, Rushmore was servicing this loan. Servicers don't gratuitously service loans. They don't gratuitously accept payments or send letters or expenses or advance for taxes and insurance because they feel like they should be doing it. The testimony was clear in this case that the servicer was servicing this loan, it was in the MSP system, and the borrower did not dispute that. When the borrower took this to stand, he did not dispute that Rushmore was servicing the loan. He admitted to actually receiving the demand letter, in this case from Rushmore. He admitted to having a conversation with Rushmore as the servicer. So the record is clear even without the power of attorney, because the power of attorney is not a necessary document for the witness to testify. But even without the power of attorney, the record was clear that Rushmore was servicing this loan, had the right to do so, and possessed the note on behalf of the plaintiff. Now, if we go to the Ortiz presumption, just because we can, for another layer of standing, there was a case that came out of the 4th DCA, Cronin versus Deutsche Bank National Trust Company. This was recently on April 3rd, 2019. And what this case does is it distinguished the Friedel versus Bank of New York Mellon, which the appellant was relying on. What the court specifically found was, and this was filed as a supplemental authority, what the court found in this case was the redactions are required by the rules of administration. The redaction of a loan number alone does not remove the Ortiz presumption. And in this case, what the court really is establishing is, let's look at the endorsement. Was the endorsement made prior to filing? Yes, the endorsement was made prior to filing. Does the endorsement on the complaint match the endorsement that was admitted into trial? Yes. End of story. So I think the record was a very thorough record made by all parties, including the judge in this case, that the judge was well within her discretion to strike the objections. In addition, the judge did hear the objections and rule on many of these objections, that the witnesses were competent witnesses within each department or each entity that testified, and the plaintiff proved standing multiple different ways, and there was nothing at trial presented by the defendant to contradict any of the findings or any of the evidence. So respectfully, I request that the court affirm the judgment in favor of the bank. Thank you.
May it please the court. Our laws are not inflexible beings where we simply just strike defenses, strike objections because of noncompliance. Cases like Binger were created for exactly these types of circumstances.
Counsel, did she sustain objections to other exhibits?
No, all the objections were overruled, and for most of them, she explicitly said, again, I'm overruling them because they are late filed.
So every one of the plaintiff's exhibits was admitted?
Every document was admitted, every testimony was allowed in over objection. And to sit here now and ask this court to weigh the factors, a task that was supposed to be the trial court's judge, is improper. Counsel wants to add facts into what was prejudicial, what was not, what would we have done, what not we have done, what was understood with the pretrial stipulation. Those are all factors which should have come out at the trial court, and the trial court should have made a finding based on those factors before it made the step of forfeiting the defendant's objections. Plaintiff says that there's no evidence that was admitted without a proper foundation, so it doesn't matter what objections were made. The assignment of mortgage in this case was admitted without any foundational testimony whatsoever. Plaintiff argued that it was self-authenticating. Nowhere in Florida law does it ever allow an assignment of mortgage to be admitted as self-authenticating. That was objected to, and again, that objection was overruled.
Counsel, you are over your time.
Thank you, Your Honor. We ask that you overrule.
All right, thank you, folks. Look, we're going to take about a 10-minute break right now, and we'll be back at 10:20.